think of empirical research, you may not immediately think of the legal profession or solving legal problems, but there's actually a trend that's catching on in legal, evidence-based decision-making. Tell us more about this, and to keep us on the forefront of this trend, we have the Associate Director of Research Innovations at the Harvard Law Access to Justice Lab, April Faith-Slaker.
Good afternoon. Thank you. So a few years ago, I had an experience that I found really eye-opening. I was living in Omaha, Nebraska, and I got a job in Chicago and had to move, and unfortunately had to break my lease. And so I decided to go about this in the most responsible way possible. I informed my landlord, gave her plenty of notice. I found a new tenant. I paid my rent up until when the new tenant was moving in. I cleaned my apartment, and I did not get my security deposit back. So I was like, I went to law school, I got this. So I looked up the law, I looked up the procedures, I sent a demand letter and said, here's the statute. It was a very nerdy demand letter. And you need to return my security deposit or provide an itemized list of the damages. And by the way, breaking a lease under Nebraska law is not enough of a reason to keep a security deposit. Thank you very much, looking forward to hearing from you. So she replied in writing and said, I'm not giving you your security deposit because you broke your lease. So in essence, she just didn't care what the law was. So I thought, I went to law school, I got this. So I was like, all right, small claims court. It's a $900 security deposit, $40 to file, no brainer. So I filed, felt good about myself, patted myself on the back, and then things got interesting. So my landlord hired a lawyer, removed the case to civil court. I moved to Chicago for the new job, wasn't able to manage the situation. I had to hire a lawyer, and this dragged out forever. So long story short, 2.5 years later, the case finally settled. And I had paid, I don't even know how much, because I don't even want to think about it, but it was over $2,000 in attorney's fees. And it settled for $1,500. And I felt like I got more justice out of the Yelp review that I wrote than I did out of the legal system. And then I thought, I had the best facts here. I was on the right side of the law. I knew my rights. I went to law school. I did everything right in this case. I had the resources to even hire an attorney, right? And I still didn't do so well in the outcome of this case. And if I can't do well in this situation, who can, right? So this is a picture of an iceberg. It's very ominous. I'm sorry. It wasn't so ominous on my computer screen, but this is very ominous. So this is an image that Rebecca Sandifer, who is a researcher in this arena, uses to demonstrate that there are a lot of civil justice problems out there in the world that we never see in the profession, that don't make it to a court, that don't make it to a lawyer. So her research says that most Americans experience at least one civil justice problem in a year. So that's over 100 million civil justice problems annually. And most of these we don't see. And so why is that? Well, if you ask people, and Rebecca Sandifer did do a giant survey on this, if you ask people what they do when they have a legal problem, typically they do nothing. They either just handle it themselves or they do nothing at all. And why is this? Well, you might think this must be because of the cost of the legal system, right? They can't afford it. Well, it's not that. It's not, in some cases it certainly is, but it's actually people don't really think of these problems that they're having as being legal in nature, and they don't think of the law as the solution to their problems. So let's talk a little bit about that iceberg, the tip that we do see. So there are problems up there too. People underutilize and suboptimally utilize the legal system. Think about default rates. So in some cases, default rates are really high, and this is not how our legal system was designed, right? These cases are not being adjudicated based on facts and the application of law. In debt collection cases, default rates are between 60 and 95%. What about the issue of self-representation? The Self-Represented Litigation Network estimates that 3 out of 5 people in civil cases go to court alone without a lawyer. So what about the supply side of this equation? Let's talk about the lawyers. Well, The legal aid system is insufficiently funded. The Legal Services Corporation, which distributes the federal funding to legal aid organizations, estimates that 50% of people that come to the legal aid organizations are turned away because there just aren't enough resources. Attorneys do pro bono, except that only about 50% of attorneys do pro bono. And who can blame attorneys for not having the time to do as much pro bono? And when you ask them why they don't do pro bono as much as they would like to, it's because of time constraints. And in fact, lawyers and the legal profession isn't the way it's portrayed on TV. We all know this. Lawyers don't make a ton of money. They don't all make a ton of money. Lawyers are, and especially recent grads, are underemployed and unemployed and have tons of student loan debt. And solo practitioners are working to make ends meet. So this is a real bummer of a presentation so far. I'm gonna turn it around. Stay with me. So the good news is that there are a lot of innovations happening, and we're hearing about some of them today at this conference. There's technology that's being harnessed in new and creative ways that is helping to make the system more efficient. There are better and more creative ways to reach the public, to inform them of their legal rights, and some of that involves partnering with other professions like the medical profession, social services. There are lawyers in elementary schools now helping to get services to people in their communities. That's really cool stuff. There are also projects that are exploring the idea of engaging non-lawyers. What piece of the puzzle can they pick up to help the system? And thinking about the fact that maybe full representation isn't always necessary. What about limited scope representation? And how can we educate lawyers about when to use that and the policies that need to change to support that? So these are really cool ideas, and this is just some of them. There's so many cool ideas out there. But what happens in the law is we typically go from an idea to implementation. I'm not saying it happens that fast. But what we do is we have an idea that seems like a good one, and then we implement it. And why is this a problem? Well, the truth is we don't actually know a whole lot about whether these things work, how they work, when they work, under what conditions they might work, and what some of the unintended consequences might be of the way in which we're implementing them. In fact, we don't actually have the research or the knowledge about how all these things, about how and when and whether these things work that we've been doing for the last 200 years. So let's take some lessons from medicine. So the medical profession, I think all of us think of as a very evidence-based, research-based practice. It wasn't always this way. So as of the 1930s, the medical profession was not research-based. It had not embraced research. And so physicians, when they had prescriptions or recommended treatments to people, did it mostly based on their own professional experience and their own intuitions, and sometimes based on dubious claims from drug companies. So this is a little scary. But over the next 40 years, the medical profession went through a transformation that involved embracing research and becoming evidence-based. So if you think about the prescriptions that any of you take, any drug that is on the market went through not one, not two, but 3 phases of rigorous testing. And so the rigorous testing that they use is called randomized control trials. You've probably heard of this. That's basically when a study randomly assigns someone to the drug versus the placebo, and then they see what happens, right? So what's interesting is that 90% of the drugs that were considered promising enough to do the first phase of research, and research is not cheap, fail the process. It's only 10% make it all the way through. This is a super scary slide. This is a slide of some of the medical practices that were discredited by research. Thank God. We've got mercury up here. Super toxic. Used to be used to treat things. Lobotomies. I don't even want to talk about that. Leeches. Okay, I do know that leeches are sometimes still used in certain cases, but leeches were used just to bleed diseases out of people's bodies. That's what they thought. And then phrenology, so the idea that bumps on your head are related to personality traits. So these are some things that were discredited by research, and I'm really glad about this. And Americans are living longer and healthier lives now, in part because of this transformation in the medical profession. So what is rigorous research, and who does it? Well, okay, so I alluded to the randomized control trials in medicine before. The Harvard Access to Justice Lab, where I do research, we do randomized control trials in the legal profession, or in the legal field. So these are basically field experiments to figure out what works and what doesn't, and under what conditions. There are other researchers doing rigorous research in this arena. I talked about Rebecca Sandifer earlier in the presentation. But it's not enough, right, to just have researchers doing academic research in academic silos and then publishing in journals that never make it to the legal profession. What's happening right now is that the legal profession and the researchers are not talking to each other. And so I think that this is in part because there are some big institutional differences between research and the field of law. So one thing, there isn't enough research out there yet. And I think that's in part because getting into the legal profession and understanding the law is complicated. There's a learning curve to that, right? And so what we can and should do as a legal profession is work to sensitize and educate researchers about the big research questions that we have. So we talk about evidence-based practice. We need practice-based evidence too. And a second thing, we have really different ways of going about truth-seeking or knowledge-seeking. So in the law, that's an adversarial process, right? And it's ultimately decided by a human decision maker. And in research, that human decision-making is replaced by the scientific process, which often involves numbers and statistics. And these are really different ways of going about things. And then finally, there's different audiences and different languages and different ways of communicating about what we're doing. So researchers tend to communicate about their findings in terms of nuances and caveats, and this drives lawyers nuts, understandably, because the legal profession needs clearer answers from the researchers. That communication and translation needs to be improved. So these problems are not insurmountable. I think that we can do a better job of bringing researchers into the profession and helping to educate them about what we're working on. And I think that we can also enter into their intellectual spaces as well. And I think the law is critically important to people's rights and liberty interests. And as a society, we can't really afford to not be working towards doing a better job with this. So thank you very much for your time. And if any of you ever move to Omaha, Nebraska, at any point, come talk to me about which landlord to boycott. Thanks.